Thanks everyone. It's great to look out and see all of you here tonight. We're a little bit worried early in the week because the numbers are coming in slowly, but it's fantastic to see you all here. My name's Hanley. I'm a member of the local Council of Amnesty International Action Group, and we're here today after about a 4-month exciting time since we were first approached by Michael and Terry to talk about the ongoing fight to get justice for Terry, and our groups agreed to get behind Terry and behind the other people who have been wrongfully convicted in their fight for compensation. So it brings us all here tonight. I'd like to begin by acknowledging the traditional owners and really welcome Gracelyn, the elder of the people, professor at this university, and many other things who are present and to our name. So thank you, Gracelyn.
Thanks very much. I'd like to say what a morning to everybody. We can welcome and video and every other language. It's a topic that a lot of people don't want to discuss, human rights. So I'm inviting on beautiful sisters Kylie and Sister Virginia, who's key traditional on the outside, and our group of that. And I want to thank Amnesty for putting this on, which they do every year, and James Cook for giving us this space, and the university a few years ago, they noted under James Cook as a big number, which means place of learning. But before I go to Dreamtime, I'd like to see the universities named after many of our wonderful Indigenous warriors who paved the way. In New Zealand and South Africa, I've seen so many amazing places named after freedom fighters. We've got a long way to go, and I said to my colleagues here, it should be mandatory, this topic, human rights. I'm saying welcome. We cover the 3 rivers, from Burdekin, Horton and Ross River, and then on the other side is Walker and Bar, and to all traditional owners. We've had 200 years of dreadful human rights violations, and some of the students, it is Professor Smith going to chip on the shoulder. It's not got a long shoulder face. It's not a chip. Because they don't want us to talk about the truth. They don't want us to talk about genocide. They want us to talk about 3% of the national population and up to 80 to 90% of people are incarcerated. And to my brother Terry, you've had a long struggle, a beautiful friend Michael. And to Robyn, who I've just met, thank you all for coming. And Peter and my colleague, we both followed years ago, I'm still going. And because the topic is so details. And Peter will be talking about a beautiful brother Calvin Conlon, as well as Stephen, and so glad your progress after a few years and the compensation. And thanks to Peter and all his colleagues. But I guess, just quickly, I'll tell them we're going to do 3 minutes for a while, sometimes it takes 10, but I'm trying to stick to 6. Calvin Conlon, our brother that was incarcerated for life, and his beautiful mum, she knocked on my door when we opened it, she collapsed. She cried, Tracy, my boy has been held in custody, and then I was like, Calvin is really challenging to break. Beautiful sister called Patricia Carton, and I put it in confidentiality because it was all in person. Her body was actually healing. And Calvin was in the park with a whole lot of young old drinking, and they picked him up and they took him in. I've got to be careful because that barrister's here, the whole case at that time. Took him in and he couldn't really write. For his fingerprint. He didn't know what he was doing. He thought he was going to get out because he's really in the jail. Something. And then, of course, Patricia was found in a devastated state. And all over the press, named Calvin Conner, raped and murdered. And to cut a long story short, when you can Google it, he was getting out from prison. Mother fought day and night, Sister Virginia, Uncle Ernie, his school teacher, and a whole lot of people. Michael, a lot of lawyers came in and helped. Because lawyers cost a lot of money. I guess if I turned my life around, I might have did it all, but nursing I chose. And my father was removed from the Burdekin at the age of 3 because of his student affair under the Protection Act and sent to the infamous Palm Island. And I guess I grew up with politics because all of our families that were sent to Palm Island were one. And hearing their stories all over Australia to the elders must be changed all the trauma that our people have suffered. But Calvin, I've written that in my book, hopefully it can soon, but a lot of people are trying to block it because it's mostly focused about human rights. And Patricia was found in such a dreadful state, and after all this humiliation of Calvin being a murderer and a rapist, the man that was actually acquitted of it, his name was Eddie Aubrey, very 6 foot tall man. And the night he did it, I've got 2 minutes there, but the night he actually did it, he changed his clothes, had blood all over it, and chucked it in the bin and jumped on the Greyhound bus onto the territory. And when he got intoxicated, he started to talk about the case of Patricia Carlton. And it went on for years. And the key that, I suppose, from a legal perspective, he actually talked about her injuries. And many experts, white and Indigenous, came and said this murder is not Indigenous. It was horrific. And the other thing was Calvin couldn't read and write. So the police had his thumbprint and he had a very well-written English confession, which put him away. But the key that happened, he told a couple of lawyers and barristers in Alice Springs who were very traumatised because when the client's hungry, you can't breach confidentiality. So to cut a long story short, that was the key because he actually spoke on what he did to his beautiful sister. And that's when I'm sure Michael will finish the story. It caused so much trauma to not only the Indigenous community but conscious white people that horrified because they knew Calvin. His lovely mother passed away before justice was given. 7 years. He talked about the brutality and cruelty. He talked about that as well. But these are not isolated cases, my friend. There's so many deaths in custody now. They want to lock up 10-year-old children in adult prisons. God help Australia. We're the only country in the world that has a treaty with the First Nations people. And then our new Premier says, no treaty town, no treaty, and he's going to block a little 10-year-old from. And all the research is done. We know what happens when children are locked away with adults. But like 6 minutes ago, I want to thank this wonderful man who knew stocks, an engineer that could have made 10,000 probably afford one in life, and he came to do human rights for free. Wonderful man. I'd like to thank each and every one of you for coming, and I'm going to push to all universities that First Nations business from a human rights perspective and unresolved genocide and trauma should be made mandatory. And we're talking about reconciliation, we can't do that without the truth. What a belief, and I'm looking forward to the truth stories. Follow this.
So just over a month ago, we're sitting there with Eric and Annie and Michael, and thinking, what will we do? And someone said, August, October the 2nd is the International Day of Wrongful Conviction, and around the world it's marked as a time that people reflect on the fact that in many of our, or in all our countries, there are people who are wrongfully convicted. And so we thought we should do something to mark that day, and we thought who would be the best person to speak, and it was pretty well unanimous that people said Robyn from the Innocence Project at Griffith University would be the ideal speaker. We contacted Robyn, and thankfully she said yes. And so it's really wonderful to welcome Robyn here this evening. Robyn's as head director of the Innocence Project. She'll talk more about what the Innocence Project is. But there's a law lecturer also at Griffith University on the Gold Coast, and she'll be joining presentation Terry, or three pictures up there, Terry, who probably basically we're all here today because that wrongful conviction more than 10 years ago, and for Michael, was working on Terry's behalf all that time. So I really ask you to welcome Robyn, and she'll do the tag team with the other presenters. So thanks for all.
Thank you. Thanks, Peter, and good evening, everyone. Thank you so much to Amnesty International for hosting this event marking the 12th International Wrongful Conviction Day, and to JCU as well for supporting it. I'd like to acknowledge the traditional custodians over these magnificent lands and waters of this region that I haven't had the privilege of visiting before, the Bindal and Walgaruka people. And I pay my deepest respects to their elders, past and present. I extend that respect to all our First Nations peoples here tonight, and to those who are not here tonight, but who we know have been impacted by the criminal law, LAW, system in this country. I acknowledge you and thank you for being prepared to share your experiences so that we might all learn, and for your resilience that gives us all hope and inspiration that we might find a better way of doing this thing that is supposed to be called justice. It is an honour for me to share this stage with Terry and Michael tonight. Tonight's theme, when our justice system fails, asks us to find inspiration in the face of failure. That's no small task, but if anyone can rise to it, it's going to be these two remarkable men. They'll bring inspiration in abundance. As for me, I will do my best. I hope to give you some insight into the challenges of dealing with wrongful conviction claims in Australia and the miracle that Terry and Michael pulled off. They're probably the last to see it like that, but that's what it really is. I'll give you an introduction generally to the topics of how wrongful convictions can happen, how we can, or more to the point, can't correct them in this country, and possible solutions to the challenges that we face in this work. Terry will share his experience of wrongful conviction, and Michael will talk about the legal challenges. For our first people, just a note that I do refer to First Nations people who are deceased and share images of a non-Indigenous man who is deceased. While I won't share any details of any crimes, some of my presentation, I acknowledge, may cause distress and be upsetting. And on a very lawyer-like note, any views that I express in this presentation are mine and not necessarily those of anyone connected to the Griffith University Innocence Project or Griffith University more broadly. Indeed, in some of what I will say, some of those people may very well vehemently disagree with me. You might also disagree with me, and you're most welcome to, of course. So our project was founded in 2002 and is based on the model of the Innocence Project, founded in New York in 1992, to assist incarcerated people who could be proven innocent through DNA innocence testing. There are 4 other wrongful conviction projects in Australia like ours, all doing amazing work. Ours, though, is the only one that's affiliated with the International Innocence Network. This network includes 71 projects across the United States, Canada, Europe, the United Kingdom, Asia and the Pacific, and more recently Africa and South America. And the network recognises Wrongful Conviction Day every year on the 2nd of October. As our old friend Reuben Hurricane Carter, who spent 20 years in prison in the USA for a crime he didn't commit, said on our ad that was on TV in around 2003-ish, our project is a practical way to help the wrongly convicted and a smart way to remind students of law that the law must be justly applied. So our project began with real excitement, driven by a hope that Australia's justice system would be as open to overturning wrongful convictions with DNA innocence testing as appeared to be the case in the USA. I have been the director for 5 years now, and I'm still learning about what happened in the preceding 20 years. It appears that within months of our project starting, the John Tong Centre, that is Queensland's quite beleaguered DNA lab, established a process whereby any request that we made for information, just information, not even talking about requests for retesting of DNA evidence, those requests for information had to go through the State's Attorney General for consideration of the entire case. Almost immediately then, our project was in effect captured by the political system, dependent on the whims of politicians. There have been, I think, about 10 Attorneys General in Queensland in the last 20 years. This revolving door has, I would say, had a significant impact on our work. But we're still here. So a quick look at what we do, starting with our casework. Our current really active cases include 8 claims of wrongful conviction. 4 of these are from women, including 1 First Nations woman, and 4 are from men, including 1 First Nations man. 3 of these people are incarcerated, 2 are on parole, and 3 have served their entire sentences but are still seeking justice. In these cases, we are currently working on getting materials, seeking right to information applications, expert reports, finding lawyers and briefing barristers. Education is also central to what we do. We have about 30 students complete our course every year. We also work on educating the public through things like our podcast that Terry and Michael participated in, public speaking, media, and other events. Sharing the details of our work, like here tonight, terrifies me, but education is key to shifting perceptions of our project, of the wrongly convicted, of our system, and the people in it. In terms of recent policy work, we have contributed to submissions to the DNA inquiries in Queensland. We were instrumental in getting a second appeal in Queensland, which was the first reform to these laws in over a century. And we have contributed submissions to the recent Making Queensland Safer reforms as well. We are working with Michael and Terry on submissions to the United Nations Human Rights Commission regarding compensation for the wrongly convicted. Many practitioners will disagree, but in our view, research is also vital in this area. Done properly, it builds critical insight into injustice. In the last few years, we have published research on women who are wrongly convicted. We have recently contributed a book chapter to an international edited collection on support for exonerees around the world. We do not perform well in that book, I will say. Following a public seminar in 2024 on wrongful convictions, we published a special edition of the Criminal Law Journal with authors who are all experts in the practicalities of wrongful conviction cases. And we're engaging in a lot more research on uncovering what we have been doing as a project over these last 23 years or so. Now, on this slide, I've included some data from the USA and Australia regarding the contributing factors to wrongful convictions. As the slide shows, the causes are quite similar, even though we are worlds apart. We have the same cases of mistaken witness identification, false confessions, perjury or false accusations, false or misleading forensic evidence, and official misconduct. False or misleading forensic evidence is obviously a problem in both countries. Recent events in Australia suggest this problem isn't going away soon. But I'm equally concerned now about advances in information technologies. We only need to look at the nightmare situation in the UK with the postal service scandal there and our robo-debt debacle here to see how much damage can be done through errors in software or algorithms that governments and corporations overlook or refuse to acknowledge. And we now know that in both cases, here and in the UK, the government and corporations were at least on notice as to concerns about the legalities and functionalities of these processes. With all of these complexities in wrongful conviction cases, it's kind of easy to see how something as, quote, easy as a DNA test is appealing in terms of uncovering wrongful convictions. Today, though, research tells us that DNA impacts relatively few wrongful conviction cases. Of the nearly 4,000 known cases of wrongful conviction in the USA that are represented on the screen there, DNA has proven a person's innocence in roughly a quarter of them. If we focus only on DNA or even just forensic science, we end up overlooking a large proportion of potential wrongful convictions and possibly the most egregious ones. DNA wrongful convictions have been a game changer in terms of understanding how wrongful convictions happen. Before DNA cases, for example, no one believed that someone would confess to a crime they did not commit. DNA cases have shown us that they do, and subsequent research into those cases is showing us how they do. We're learning, for example, how young people are particularly vulnerable to coercive practices of some police officers and potentially lawyers too. There is a lot of concern about young kids, particularly First Nations kids, pleading guilty to crimes they did not commit. A false guilty plea is still a wrongful conviction, as Terry said in our podcast episode recently. What DNA cases do not show us is, for example, how women are often wrongly convicted. Women don't tend to be convicted of crimes like rapes and murders for which many men can possibly be and have been proven innocent through DNA innocence testing. You may have heard of Lindy Chamberlain and Kathleen Folbig, how they were convicted, likely in part because of expectations of how women or mothers would or should behave. While the evidence at trial might come from experts or eyewitnesses or victims, biases can feed into the information gathering and decision-making processes. Similarly, when we consider race, it undoubtedly feeds into the decision-making process at many different, if not all, points along the way in the investigation and prosecution process. So what is the way through the process? Well, I thought about how to explain it and the pathways to exoneration in Australia, and this was the best that I could come up with. There is no pathway. It's a maze of dead ends and U-turns and uncertainty. There is no rhyme or reason to this process, so please don't worry if the maze on the screen doesn't make sense to you. It's not supposed to. Briefly though, after a person is convicted in Australia, they have usually 28 days to appeal their conviction, which even then is limited largely to questions of law, not factual innocence. Second appeals, if a person can get one, often lead to another dead end, although cases like Henry Keogh's in South Australia show the process can work if the incredibly high barriers can be overcome. The High Court is another forum with incredibly high barriers to getting a foot in the door. Andrew Mallard's case is an excellent example of how even a decision in the High Court can be essentially dependent on luck, as his former barrister, the Honourable Malcolm McCusker, has said. And justice should not be about luck. Then we have referrals to Attorneys General, inquests, inquiries, royal commissions. We saw some of these in Lindy Chamberlain's case. Her first inquest arrived at the conclusion that it was likely a dingo that had taken her baby, only for those findings to be discarded by the criminal justice system and for her to later be wrongly convicted. First Nations woman Robyn case here in Queensland is a good example of the pardon process. Robyn has passed away since her pardon, but her case continues to serve as an example for us, first of how the law and legal system gets it wrong, particularly with First Nations people, and how the Court of Appeal acknowledged the miscarriage of justice in this case and was convinced to put things right. There may be members of the legal profession here now who will be thinking about the finality principle. I understand and respect that finality in our law is important. We need some end point, but as I often like to quote Lord Atkin, born in Tank Street, Brisbane in 1867, finality is a good thing, but justice is better. I think our project at Griffith has always done and continues to do extraordinary work. I think it's important, though, to reflect on the fact that in the 23 years or so of our existence, we haven't had any exonerations. We have received nearly 1,000 applications or inquiries in that time. If I were to cynically say that half of those people who applied were just trying it on and were guilty, that leaves us with about 500 cases. Even then, if I got super cynical and suspicious and said even half of that lot were guilty too, that's still a couple of hundred people who have contacted us with legitimate claims of wrongful conviction. I'm often accused of being naive in this work, believing people who say that they have been wrongly convicted. But I am not so naive as to think that our system is so perfect that it did not fail in a good many of these cases, and that, for whatever reason, these people haven't received justice. I fear this is not very inspiring, and I'm sorry, but it's about to get less so. Reflecting on the challenges for us in this work as I see them. First, access to information. So next is the loss or destruction of evidence. Once a defendant's appeal period has expired, they generally have no right to information about their case. After that 28-day period for an appeal to be lodged, evidence can be returned to wherever it came from or even destroyed. We have no preservation of evidence legislation in Australia. Every state in the USA has preservation of evidence legislation. Here, there's nothing we can do when evidence is lost or destroyed. And on at least one occasion, that has occurred only after we disclosed that we were interested in a particular piece of evidence. We look at cases that everyone else in the profession and justice system has given up on. But we don't act as lawyers. We don't have a solicitor-client relationship with our applicants. We don't have legal privilege, and we can't give legal advice. We rely on law firms and legal aid to take on our cases, but this rarely happens. We have had some success in recent years with 3 of our cases now with legal aid or lawyers, but this was hard fought in each case and came with significant delays. Our cases are difficult, there's no doubt about that. But I'm finding that even defence lawyers exist in this system, are part of the system. And perhaps they believe in it because they are part of it. Even in upholding the rule of law and a person's right to a defence, they may not necessarily be open to the possibility of wrongful convictions. I was at a function recently and seated next to a lawyer who has an amazing history of pro bono work and commitment to social justice. I was excited about the opportunity to talk to this man. Soon after our introductions, he leaned over and said to me, "But you know they're all guilty, right?" Anyway, our challenges can also lie in smaller details with lawyers. The most dedicated and believing defence lawyers can still have commercial realities that they have to contend with, and that can impact on their decision to take on our cases or not. our abilities to investigate matters is also compromised for various reasons. But we know in the 4,000 cases in the USA and every other case that we can see, the errors are only uncovered through a careful, painstaking reinvestigation of the entire case. Now, I've painted a very bleak picture here, but there are so many wonderful people around the world, including the wrongly convicted themselves, advocating for the wrongly convicted. These people are a constant source of inspiration, so I want to turn to some of the solutions that they're currently working on. The Wrongful Conviction International Law Task Force is a global team of members of International Innocence Network projects advocating for the establishment of innocence, exoneration and compensation as universal human rights. They are building international momentum with 15 reports so far delivered to the Human Rights Commission. Michael and I recently contributed to this group for the preparation of their Australian report. The next possible solution or way forward closer to home is establishing, as we hope you all are going to become more familiar with, what is commonly referred to as a Criminal Cases Review Commission. Examples of these are already found in the UK, Canada, Norway, New Zealand, and initially, I will admit, I was not sure about this option. These organisations have their critics and their controversies, and I wasn't overly optimistic about one being established here. But given the circumstances that I have just explained to you that challenge our own work, I am 100% on board with this idea, led by the collective wisdom of people like Michael and Terry and the Innocence Project's Advisory Board, who all have a lot of experience in the area of criminal defence work. Considering these issues, I've set out some of the possibilities for you of what a Criminal Cases Review Commission might look like, such that it might be able to overcome some of the problems and challenges that I've referred to earlier in our work. It would review matters using powers to investigate and draw on relevant expertise and knowledge, for example, in science and First Nations experiences of the law and cultural practices. It could have the power to refer cases for legal representation and then to appellate courts. It would have money, a budget at least for expert reports, and the means for regulating the award and payment of compensation for wrongful conviction. And finally, it would support the wrongly convicted and victims of crime. I wouldn't want them to be lost in this reform. And finally, provide for relevant research that would enable the organisation to do high-quality, data-driven work. But even without a CCRC, there is some low-hanging fruit that would help us now. Legislative reforms to, for example, preserve evidence, to streamline the process of access to information and evidence, and provide a right to compensation. And what else might help us? Lawyers to take on our cases. And of course, we'll need money. But we would like money to pay for reports, legal representatives, more research assistance and things like that. Terry and Michael will speak more on compensation shortly. Briefly, though, by way of background, support for exonerees in this country is non-existent. Other than what help they get from their very good friends, families and charities, the wrongly convicted receive nothing upon their release from prison. We as a country accept that when people have been victims of crime, they are entitled to be compensated and various needs met. There are whole processes, government departments set up for this in Queensland and around the country. These systems are quite capable of differentiating between different types of victimisation, impacts of crime and circumstances, determining how much to pay and what support to provide. Yet when our system creates the wrong, there isn't any form of acknowledgement, not even an apology, let alone compensation for the wrongly convicted. Now, Australia is a signatory to and has ratified the International Covenant on Civil and Political Rights. Article 14.6 of this covenant gives a person who was wrongly convicted a right to compensation. Essentially, Article 14.6 says that where a person has suffered punishment as a result of a wrongful conviction, they shall be compensated according to law. The ICCPR is Australian law, but we are one of only a handful of signatories to maintain a reservation, specifically with respect to Article 14.6. So this means that we have said we'll sign up to the ICCPR, but the terms of our reservation are that the provision of compensation for miscarriage of justice in the circumstances contemplated in 14.6 may be by administrative procedures rather than pursuant to specific legal provision. In other words, no right to compensation will stick with our so-called administrative procedures, maybe. Legislation is possible, though, and preferable. The ACT's Human Rights Act incorporates Article 14.6 virtually word for word. People in that territory have a right to claim compensation if they satisfy the threshold. Queensland, like Victoria, has a Human Rights Act, but neither state incorporated this right to compensation like the ACT did. Don't worry about reading it, it's just boring legal jargon. The USA has a similar reservation to 14.6 that we do in Australia, but 40 of their states now have some form of compensation legislation, including several states who have passed such legislation this year. And we all know what kind of show has been going down in the USA this year. So for them to still have some of their legislatures see this issue through, I think is a pretty woeful example of Australia's response. Where there is no legislation for compensation, we are left with the unsatisfactory administrative procedure, applying for an ex gratia payment. This brief snapshot of some of these payments gives you an idea of how random and unfair this administrative procedure is. None of this makes any sense, and it certainly isn't the justice that these people or any other wrongly convicted person in this country deserve. So I'm going to wrap up now, but I want to conclude by sharing with you what many or most people say to us when they apply to our project. They say the court didn't get the whole story. They didn't hear everything. The truth is something the common law struggles with in many ways. The truth, for whatever reason, seems to threaten the system. And without wanting to minimise the experiences of exonerees like Terry, could I dare suggest that the conviction that the common law legal system is a perfect system and the best there is indeed a wrongful conviction. When people say to me, "Oh, but the system has worked for so long," I think, really? Who has it worked for? The wrongly convicted? No. Victims of crime? Don't think so. First Nations people? No. People of colour? No. Women and children? No. No. Culturally and linguistically diverse people? No. Those in poverty? No. Those with disability or impairment? No. I attended a criminal law seminar last week with Professor Nerina Feen, who in her new book quoted philosopher Thomas Nagel, who said, "The pursuit of truth requires a habitual readiness to attack one's own convictions." On institutional change in our system, Professor Nafeen continued, "It is difficult, but not impossible, to contemplate how to do things differently because the problem is deep, seemingly entrenched and enduring. But truth and justice depend on it. When we attack our own convictions in the pursuit of truth," Nafeen continues, "then truth can form the reply to power." And to paraphrase the amazing Amy McQuire, and I hope I'm doing this appropriately, that we need to find a form of justice that has long been denied and to uncover a truth that will always catch the light. I love that idea of truth always catching the light. Thank you all for being here this evening and for indulging me at the end here with my personal hope for a brave new world. To bring it back to earth and back to this world, it is my great honour to introduce Terry Irving to you.